Good morning. Today we are going to discuss the types of defamation. In the previous lecture, we have seen what is defamation. I have told you defamation is a false statement published against the reputation of a person so that the people in the society, the right thinking people in the society, they try to avoid him or shun him. That is defamation. It is a taunt against the reputation of other. Now there are two types of defamation. One is libel and the other is slander. Libel and slander. We'll first see what is libel. Libel is a publication of a false statement. So all the essentials of defamation must be there because it is a type of defamation only, na? Therefore, what is libel? Libel is a publication of a false statement or a defamatory statement in some permanent form tending to injure the reputation of another person without lawful justification or excuse. Means what is libel? Libel is a defamation. Therefore, all the essentials of defamation must be fulfilled. That is, it must be a false statement. Second, it must be referring to the plaintiff. Third, it must be affecting the reputation of the other. Fourth, it must be published. Therefore, all the essentials of defamation are completed. Now, one more essential is there which should be there if it must be a libel. That is, the false statement or a defamatory statement must be in a permanent form. Permanent form means either it should be written, either it should be published in a newspaper, an article or a book, or it can be a film also. It can be a wax effigy also. It can be a caricature also. It can be carved on a stone also. So, defamatory must be some kind of a permanent statement that will be called as a libel. So what is libel? Libel is a defamation which is in a permanent form. Got it? Therefore, all the essentials of defamation must be completed. One additional point must be there, that it must be in a permanent form. This is the first kind of defamation. The second defamation is slander. What is slander? Slander is an oral statement or a gesture, you can say. It is a verbal or a oral statement. It is in a transitory form. Transitory form means what will happen? I will tell to somebody else, some one person. That one person will tell to 10 more people. This 10 more people will tell to some 20 people. This 20, and further it will go on, and it will be like a rumor which will be spreading in the society. So, slander is an oral statement which is in a transitory form tending to injure the reputation of a person. It is published to the other person. It is a transitory form, and that is going to affect the reputation of the person and without lawful justification and excuse. See, in the libel also we have seen that there must be without any lawful justification. Means the person who is making the publication, he is not having any kind of excuse. Defamation is done and the defendant is not having any kind of excuse. So no justification is there, no excuse is there that why you said this, why you told this false thing to one of the person. That will be called as a defamation. So slander is in an oral statement, it is in a transitory form, while libel is in a permanent form. This you can say is a basic difference between libel and slander. Libel is in a permanent form, slander is in an oral form. I told you it is like a rumor which is spread in the society by people. Both are defamation. In our Bharatiya Nyaya Sanhita or our previous Indian Penal Code, defamation was an offence, is an offence, and both are dealt as a crime. Both are dealt in one definition only of defamation, that a statement which is false, which may be oral or in a permanent form. In a tort, you make a difference. So libel is permanent form, slander is oral and transitory form. So one more thing is there in these two things, that libel is actionable per se, while slander is not actionable per se. So we have to first understand what is actionable per se. Actionable per se means when I file a case in a court, there is no need that I should prove to the court that what loss has occurred to me. Means when the plaintiff files a case for libel, he has to just prove in the court that this is a libel. This is in a permanent form. This is a defamation. He has to prove all the essentials of defamation, and one more thing, he has to prove that it is in a permanent form. Once he proves it as a permanent form, there is no need that he should tell what loss has occurred, what damage has occurred, what mental agony I have faced. Nothing he should prove. He should only prove that this is libel. That is called as actionable per se. So libel is actionable per se, but slander is not actionable per se. It means when the plaintiff files a case for slander, he has to prove the essentials of defamation. Which essentials? That it is a false statement, it is a defamatory statement, it refers to the plaintiff, isn't it? It has been published, it is injuring my reputation. Those essential he has to prove. But if it is a slander, he has to prove that, see, this is an oral and a transitory form. But if the plaintiff wants to get compensation, then he has to prove that because of this oral statement, such an amount of loss has taken place. Such damage has occurred place. That he has to prove. Therefore, we call as slander is not actionable per se. I'll repeat again. Libel is actionable per se. It means in the court, the plaintiff need not prove what loss he has faced. But slander is not actionable per se. It means he has to prove in the court that what loss he has suffered. If he proves that what loss he has suffered, then only he will get compensation. Understanding it na? Libel is actionable per se and slander is not actionable per se. So we'll go now further. What I told you, when the plaintiff files a case for slander, he has to prove that what loss he has suffered. But there are 5 different circumstances where slander is like libel. It means slander is actionable per se. There the plaintiff need not prove what loss he has faced, what loss he has suffered. Only 5 different circumstances are there where slander is actionable per se. The 5 circumstances are when the plaintiff is telling that the defendant has made accusation against me relating to a criminal offense. Means the defendant has spread a rumor in all the society that I have done a criminal offense, a crime. So that accusation, if he proves an accusation, it is presumed that he has suffered the loss. Therefore, he need not prove how much loss he has faced. Okay. Therefore, accusation relating to a criminal charge. Accusation relating to a virulent disease means he is not suffering from the disease, but the defendant has spread in the society that is suffering from some virulent kind of disease. So what people will do? People will avoid him because they don't want to get that disease. It is a contagious disease, virulent disease. Therefore, this is presumed here that he has suffered the loss. Okay, I told you two points which are the exceptions for the general rule that slander is not actionable per se. In these 5 cases, slander is actionable per se. First is aspersion relating to criminal charge or accusation of a criminal charge, accusation relating to virulent disease, accusation or aspersion relating to caste means the defendant is telling that the plaintiff is of a lower caste. So, if an upper caste person is being told as a lower caste, it can be a slander which can be a actionable per se. Okay. Next is accusation relating to his profession or trade. Means he is not a good professional. He is doing wrong things in his trade. That poor person, that plaintiff is a good person. He is doing everything right. But he is spreading like these things. So if accusation is relating to his profession or trade, then also slander is actionable per se. And the fifth is aspersion relating to unchastity of a woman or a girl. Means this defendant is spreading in the society that the girl is unchaste. The woman is unchaste. She is characterless. Like these things, if they are spread in the society, then what the woman will do? The woman knows that she is good. The people, some of her relatives or friends, they know that she is good. But how many people they can stop? Na? People are going to talk about that girl or the woman. Therefore, if the woman files a case in a court, she has to just prove that the defendant is spreading false statement relating to her character, relating to her chastity in the society. Law presumes here that they have suffered loss. So in slander, in 5 different circumstances, law presumes that they have suffered the loss. Therefore, there is no need to prove the loss. So in these cases, slander is actionable per se. I'll repeat again. Libel is actionable per se. However, slander is not actionable per se. In only 5 cases, slander becomes actionable per se. These are the 2 types of defamation, libel and slander. Okay, see you in the next video. Bye bye.